So you guys asked me to do a deep dive on this copyright report, and I'm so glad that I did. This copyright report is so huge. I am basically at this point where I think I need to file a lawsuit on behalf of independent artists. I'm going to explain why. Look, here's what happened. The Copyright Office, the head boss in charge, who is the person that reports to Congress, to federal agencies, basically, and says, hey, this is what should happen related to copyright. They put out these reports. That's what this is. It's extremely influential, and it's been so persuasive to me that as it relates to these pending lawsuits against music, AI, generative platforms, Suno, Udio, we know that there are lawsuits against them by major record labels, but who's representing the independent artists? There's going to be a big payday, very likely, based on this report, based on what likely is going to happen with these cases now moving forward. And I was just thinking today, what about all the independent artists who had their music trained on without permission, who are not going to get paid? I'm going to talk about this more. In the meantime, if you're interested, if you want to be a part of this, just get on my email list, and I'm going to be sending updates as I think through how we're going to do this. But for today, what I'm going to talk about is this report, because after this report came out, the head boss in charge, which is Shira Perlmutter, she was the director of the Copyright Office. She got an email from the White House saying, hey, you're terminated. And we don't know any other reason why this happened. I'll leave the speculation from the political side for you guys in the comments, but we do know that this report came out and then she got fired. So what does this report say? And why does it matter for what is otherwise kind of a pro-tech administration when this report seems to be leaning towards the protection of creatives, the protection of music and books and movies, and making sure that these AI companies can't just come in and freely train without permission, without paying anything. Now, one thing I do want to point out is that this report, it's actually the third section. So the Copyright Office had been going through and analyzing copyrightability of artificial intelligence, right? What is allowable and not allowable. And this section in particular deals with what can AI companies train on? That's a really important question because we have some of the biggest cases still pending related to, is it okay for a company to go and just freely train on copyrighted work without permission? And will it have no liability in doing so? But what I wanted to point out is that this is the preliminary report. And there's this little notice on this preliminary report that I thought was really interesting because it goes, this is a final version of this preliminary report, but the final version will be published in the future without any substantive changes expected in the analysis or conclusion. So I go, well, since Miss Perlmutter has been terminated, someone new is going to step into her position. I'm really curious if this report ends up substantially changing based on what it's recommending. All right, so look, we're going to dive into the actual report. Let me just give you some of the sections that we're not going to go over so very much, but just so you know, in this report, they basically deep dived into like neural networks. They're explaining with AI how it works. They're like, look, AI and what this neural network thing is, it's basically a supercharged web that's like a brain, and there's lots of connections, and it is how the AI learns patterns. And so some of the keywords you want to remember are weights, for example. The word weights is kind of like light switches. If you're in this neural network, as you're going along, there's information that is in this network. And basically, with the weights of what the information is, you turn it on, you turn it off. So that's one thing to remember. Another one is a token. And so they go, it's interesting because AI has tokens of how it reads text. It doesn't read a sentence the way we do. And so we'll say a token is basically just like text. It might be punctuation, it might be a comma. So they went through this really in-depth analysis of like how AI works. And they went into like the training of the actual AI, and they go, look, there's a bunch of different ways that AI will be trained. And what's been so interesting for the Copyright Office to uncover is that AI needs to train on high quality stuff. So they go, for example, when we have these companies that are going and let's say just taking, let's say Shutterstock photos. You guys have seen these with like the overlays and the watermarks because they don't want you to steal their photos. So when there are watermarks, when things are low resolution, the AI doesn't understand the distinction of what that is to the image. And so it ends up being a low value training material because then the AI gets confused. It's like, oh, when I have this post that I'm training on from social media and I see the likes down here and I see the hearts and I see all the comments, this is all data that confuses the AI. And so what the Copyright Office kind of went through is like, look, in the training, the quality of what it's training on really matters. And that matters for these lawsuits of what these companies went and accessed, whether they did it with permission, whether they broke through a paywall, or whether something was just freely on the internet. So it's not just basically gathering data, but we know this scraping, right? It's like AI will go and scrape whatever, web pages, and we've talked about Spotify. We're like, well, we know that the major record labels are suing Suno, Udio, Anthropic, right? All in the same allegations of copyright infringement and saying you went and scraped through these publicly available. What does that mean? Did you go to Spotify? Well, it's not really publicly available, but it is. What was amazing is that the Copyright Office pointed out, for example, there was research by Cornell which trained a generative image model over 70 million Creative Commons licenses. And so they go, the volume of data that's needed to train AI is really important here because they go, look, in the conversation of like trying to be fair, AI is super great. And AI is a advancement of all kinds of ways in tech, and it's going to help in a lot of great ways. And so to be fair in this conversation, we're like, well, in order to train the AI, it needs to have access to a ton of stuff. So the Copyright Office went through and actually examined, what does that mean? Like, are you needing not just tens of millions? Do you need billions of things, right? So we have to give it access to this. So how are they actually getting access is a very important piece of the consideration. The Copyright Office is like, in the instance that they're saying that they went and accessed something when someone said no, and they went and took it anyway, or when there was a paywall, right? So meaning you are supposed to pay some kind of subscription to get onto the platform, like Spotify, then in these different instances, it's going to weigh away from it being okay, right? So we're going to talk about what that means as far as fair use. And the Copyright Office says for training purposes, the amount that it's training on, sometimes it can be less and it's totally fine. And they gave examples. But then they go, but let's talk about infringement. This is the big piece here. And also for us creatives. And then as I was thinking through this, I go, well, this is interesting because I go, in these lawsuits where the major record labels sued and they said, we think that Suno and Udio have been training on publicly available music. And then these companies responded and they go, yeah, we have. But we think that it's fair use because fair use is a doctrine that allows for this kind of behavior of using someone else's copyrighted stuff without permission. And even if it actually is copyright infringement, it's a defense. So it's a protection. So anyway, the Copyright Office goes through this. It goes, in order for there to be training, you have to download a copy of the thing. The best version for AI to train on is going to be the actual thing. So they typically will want to download a copy. That's copyright infringement. A protected right for a copyright owner is to make copies all by themselves. No one else gets to make copies without their permission. So that by itself, the downloading of the creative thing, copyright infringement. And then they go on, they're like, well, and also there's this memorization piece. And so remember we use that word weights in the information in the neural network. They go, as they're memorizing, to add weights, to add little pockets of information, that there has to be replication. So they have to make copies internally to remember what it is, right? So they go, copyright infringement. So the Copyright Office basically goes through and just says, okay, so there has been instances of copyright infringement, but does it fall under fair use? And that's where we're going to jump into the actual report. Let me go to this. So we're starting on page 32. Fair use is a judge-made doctrine, which is codified in section 107 of the Copyright Act. And there's 4 factors. Now, when a court looks at, well, was the use fair use? Those 4 factors are this. They go, what's the purpose and character of the use? Meaning, like, was it for commercial nature or are you teaching a class, right? Is this a nonprofit educational purpose? So like, what was the reason you were doing it? That's factor number 1. Number 2 is, what's the nature of the copyrighted work that you're copying? In other words, are you copying something that wasn't published yet? Did you get a hold of it somehow? Because your producer was sending it secretly and no one was supposed to see this. So what's the nature of it? Is it something that is really creative? Is it something that's just data? And so the courts over time in analyzing this is that if it's something that, for example, is creative, it typically is going to be more protected. That means fair use typically is going to be less available if you're taking someone's artwork without permission, right? And then doing something with it. So that's what they mean when they say the nature of the actual work that was taken. Number 3, the amount of what was used. Okay, did you use the whole thing? Did you only use a little bit? And then number 4, the effect on the potential market. So in the analysis of AI, what the Copyright Office looks at is going to be number 1 and number 4. These are the factors that the Copyright Office cares about the most. So what was interesting is that the Copyright Office put out a notice, and this notice goes to basically anyone who wants to submit a public comment. And so there was all kinds of organizations and businesses that gave feedback to the Copyright Office either way, and just being like, it's so good, we should do this. It's so bad, don't do it. And so the Copyright Office goes through and, for example, talked about what the Copyright Alliance had to share on whether fair use should apply. So the Copyright Alliance warned that the widespread unauthorized ingestion of copyrighted works would certainly appear to cause immeasurable harm to creators and copyright owners, both by destroying existing, nascent, and to-be-developed licensing markets with low-quality material. And basically just being like, we're seeing this happening already with so much use of just AI music flooding the different music marketplace platforms. And we're seeing that now this is really diluting overall the opportunity for someone to get discovered. Okay, so we're seeing the downstream effects of it. On the other hand, many warned that requiring AI companies to license works and training data would stifle development. It's for critical tech. Later on in the report, they kind of talk about, well, the reality is that the licensing would likely be in the billions of dollars because most of these companies would end up having to do licenses where they're paying ongoing royalties. It wouldn't just be a one-time license. And they go, this is going to kill the opportunity for smaller AI companies to do this. And I'm kind of curious what you guys think about that. So I go, well, it sounds like to me what you just said is that there's potentially billions of dollars that would be paid to music creators or music rights holders that aren't being paid because you just put a dollar amount on it. Now, the idea is not to stifle tech development, right? But it's essentially, can we do this so that you are buying into a system, a music business that is currently in place right now that has licensing in place? You know, if you're a business and you want to play music in your restaurant, you have to go and get a license from every single performance rights organization. For example, here in the United States, there's 6 of them, and each one represents different music. So if you want to be fully covered, you need to get a license from every single one. And so why does a tech company get to come in and be like, well, we're also a business, but we're not going to play by those rules? That's what's being argued here. If you're needing legal help with your career, your business, we got you covered. Feel free to reach out to my law firm. I'm honored to say we have over 100 5-star Google reviews. We offer free case evaluations, which just means that you can give us a call, you can email us, no commitment. We'll just see how we can help. We look forward to hearing from you. All right, so in the first factor, right? So courts typically stress 2 main elements. It's really the commerciality of it and whether it has been transformed. Some courts have also evaluated whether the defendant had lawful access to the work. How did they get access? So the Copyright Office agrees that different uses during AI development and deployment require separate considerations. So like basically the Copyright Office goes, look, we want to be fair here. When you are an AI company and you are training on certain things, right? You are gathering data and it's for a completely different purpose that you're going to transform it into something new. You are going to take all the data that you just learned and you're going to now have, let's say, a new database, something that is, again, just this word transformative. This is an important piece because there are findings of fair use and even the Copyright Office goes, well, in fact, I'll just let them say it themselves. In assessing transformativeness, the question is whether the new work merely supersedes the object of the original creation or instead adds something new. That's the key language. Does it add something new? Is it going to advance, right, the purposes of copyright? What was interesting, I'll point out one of these cases. The court goes, the point of copyright is to promote the progress of science and the arts, okay, without diminishing the incentive to create. That's the idea of fair use. It's that if we're doing a parody, if we are doing an educational reaction video to be like, hey, in this particular song compared to this song, this was the difference, these were the differences in keys, or this is how it was written, and there's some educational piece to it. These are examples of when fair use typically does apply because we want to make sure that we are promoting the progress of science and arts. So in that framework, we go, well, how could we make this potentially fit? So although the transformation piece often does lead to finding fair use, not every transformative use is a fair one. So beyond these principles, case law provides additional guideposts. Uses that merely change the medium or spare the user inconvenience are not transformative. By contrast, copying to make available information that the content of the works copied can be transformative where it does not provide substitutes for those works. So basically, they use this example of Google Books, and they go, what Google did is Google went and scanned thousands of books, like the full text, and they created a new database, and they got sued. But they were actually successful in arguing fair use because they go, well, we did take all of the books in order to create this new platform, but it's a search platform. We're not recreating the books to like sell the books. We're using the books in this very highly transformative purpose of having a search engine database. And they were very successful with this, and the court agreed. So the court concluding that the creation of a full text searchable database was quintessentially transformative because the result of a word search is different in purpose, character expression, meaning, and message from the page, meaning the book, from which it was drawn. They go on to basically give some commenter views on either side of this. And then the Copyright Office states several commenters described the use of copyrighted works to train AI models as fundamentally different from the purposes of those works because it is non-expressive. And this made me laugh. Do you guys remember Anthropic is the other one getting sued? So Anthropic had something to say. It goes, for example, Anthropic asserted that to the extent copyrighted works are used in training data, it is for analysis of statistical relationships between words and concepts unrelated to any expressive purpose for the work. Just to kind of clarify on this, they're talking about expressive versus non-expressive. So what they mean is that they're like the final end product that's generated. Is the final end product like data? Is it research? That would be non-expressive. If it's expressive, right, it's something that's like a poem. It's emotion, right? It is expressing in a way from the stuff that it trained on. So when we get back to these lawsuits against the music AI companies, we go, well, the analysis is you took very expressive songs, right? And you trained the AI. And now what you do is you create new songs. So you have an output that is an expressive output. What Anthropic was saying, at least in its comment to the Copyright Office, is like, well, if you're just training data and you're just trying to show statistical relationships between words and concepts, it should be fair use. We'll see what happens with Anthropic, but that's its comment. One commenter observed that the courts never said there is a non-expressive use doctrine. The relevant inquiry is not whether the use is expressive or non-expressive. Rather, it's just whether the use is transformative as one consideration in the four-factor analysis. In the words of the Authors Guild, AI companies seek out published books for training precisely because of their expressive content as high quality, professionally authored works are vital to enabling an LLM to produce outputs that mimic human language, story structure, character development, and themes. In other words, having a generative AI foundation model with a very large database in itself, the Copyright Office is saying it is transformative. And that's why we've been like, wow, with these lawsuits, it's a strong argument because what they're claiming is they go, yes, we use the songs. Yes, we make new songs as part of our tech, but what we actually developed here is technology. And that's where this could be very successful, right? If they can say it's fair use because what we developed has a utility purpose. It is technology. Many AI models, however, are meant to perform a variety of functions, some of which may be distinct from the purpose of the copyrighted works that they are trained on. So this one really stood out to me, and it goes on the other end of the spectrum. Is training a model to generate outputs that are substantially similar to copyrighted works in the dataset. For example, foundation image model might be further trained on images from a popular animated series and deployed to generate images of characters from that series. Unlike cases where copying computer programs to access their functional elements was necessary to create new interoperable works using images or sound recordings to train a model that generates similar expressive outputs does not merely remove a technical barrier to productive competition. In such cases, unless the original work itself is being targeted for comment or parody, it's hard to see the use as transformative. Let me put it this way. If I was representing the major record labels, this report is so unbelievably powerful because what they just said there is they go, we don't really see that this is transformative. Where you are doing something with your tech in that you are just training to do something that is competitive in nature, that is essentially the same thing in nature, it's hard for us to find that this is going to be transformative. And if transformation is a huge piece of this factor, well, they may fail for that reason alone. So the Copyright Office just talks about, well, if you do use AI in other ways, if you're using it to like remove unwanted distortion on sound recordings, that's different, right? You're using it as a tool. But because generative AI models may simultaneously serve transformative and non-transformative purposes, restrictions on their outputs can shape assessment of the purpose and character of the use. This goes back to when these companies are like, well, we have filters in place. And then that was a concession in the Anthropic lawsuit where they're like, we are basically going to resolve one little issue. We're agreeing that we're going to make sure to really toughen up our filters and to make sure that even though previously, when people would use Claude, full lyrics for copyrighted music was being generated just with prompts. And so that was the same thing with Suno, with Udio. You had these major labels who were like, people are literally generating our songs verbatim with just prompts. And so they go for all those reasons. That's why we think there's copyright infringement, because they didn't know at the time of filing. They didn't know how this was being done. Were there copies being made, right? Are we memorizing the information? How is this working? But they go, all we do know is that the AI is spitting out our stuff. And if it's spitting out our stuff, that means you trained on it. If you trained on it without authorization, that's a violation of our exclusive copyright rights. The amount used, so it goes downloading works, curating them into a training dataset, and training on that dataset generally involves using all or substantially all of those works. Such wholesale taking ordinarily weighs against fair use, because remember, part of this is how much did you use? If we're reacting to someone's video and we're doing it for commentary, criticism, and we use the entire video, that might have been necessary, but typically fair use is going to weigh towards using the least amount that you needed to in order to make, let's say, your educational point. And so they go like, what's inherent with AI training is that they are typically wholesale taking. They're using the entire thing. Sometimes when we're talking about just copyright infringement in general, sampling is a big thing. And what portion was used of something can really make a big difference, right? Did you take just the 2 words, but were those 2 words, the main 2 words, the hook, the thing that everyone knows? Or was it 2 words that are just arbitrary and everyone uses it? This is why this is a balancing test. And I want to emphasize that of the fair use analysis. It's not just one factor, it's taking them all together, but there are factors that have a little bit more weight than others, as you guys are seeing. Okay, so then the Copyright Office goes on. Was the amount made available to the public? That is a factor that needs to be considered. But in the basically 4-factor analysis of 1, okay, the purpose and the character, is it for commercial or is it for nonprofit educational use? And even the Copyright Office made the point. They're like, even if it's a nonprofit use, it's still, you don't just have free reign to use whatever, because there can be a commercial purpose even for a nonprofit that has good intentions, that plans on donating to the good cause. That goes into the analysis. The nature of what was copied. So in this case, music, it is creative music, right? Creative stuff. If it is creative, then typically there's going to be less fair use in a competitor coming along and being like, we're going to train on your stuff and we're going to make a competing product for essentially the same thing. And then the third one, the amount that was used. Well, we just went through it. The amount used for AI training is typically the entire thing. And then, of course, the effect on the potential market. So this is the 4th factor. The effect of the potential market or the value of the original copyrighted work. Okay, the Supreme Court has twice described this factor as undoubtedly the single most important element of fair use. Although it's important, will vary not only with the amount of harm, but also with the relative strength of the showing of other factors. Okay, so this is a big one, right? So if we can prove that someone comes in and they take your stuff, they create a competing product, it's for commercial purposes, they're making money from it. Does this sound familiar at all? And then it ends up impacting the market value. So this goes back to the whole, well, if you're flooding the market now with competing products, that pretty good, right? Do they compete? And the answer is yes. All right, so what's the problem? Well, there's going to be potentially lost sales. The National Association of Broadcasters provided an example of nearly word-for-word copies of a local news station's stories being reproduced by a generative AI system without permission from the station or its owners, illustrating how AI-generated news has the potential to substitute for and supplement the market for copyrighted broadcast content on which the AI systems have been trained. Because one of our questions is always, well, do you care? If you hear an AI song, do you care about the origination, or would you know? Would you know? Are we going to potentially have an actual problem with originally human-made stuff with now competing products of AI? It's happening one way or another. We're just discussing the origination issue, because in this big transition of what our new worldview is on creating music, creating anything, in conjunction with AI or using AI solely. This is where we are now. But the problem and the thing that we're focusing on is what happened when these companies decided just to come on in, not license anything, and do they need to pay for that? The Copyright Office talks about the market dilution. Okay, we just discussed that. Market harm can also stem from AI models' generation of material stylistically similar to works in their training data, right? So remember, we were talking about the weights, and the Copyright Office is like, well, if something has the ability to spit out something else that is almost identical, it's because it's in its memory. It's because it has a copy, so to speak. So the Copyright Office says, look, it's like lost licensing opportunities. That's the bottom line here. There's going to be lost revenue, lost licensing opportunities. A number of commenters disputed that current licensing activity demonstrates the feasibility of broad implementation of voluntary licensing. They argued that licensing cannot provide the quantity, diversity, or type of data that many AI systems require, that licensing such data would be prohibitively expensive and available only to certain developers for certain copyrighted works. And look, let's play devil's advocate for a second. Is it really tough licensing a lot of music, especially when you're telling me we're in the tens of millions of pieces of data? Sure. Welcome to the music business. When we just go to clear one song, it is very expensive. There's a lot of time that goes into this, but I don't really feel so bad when we're talking about companies that have raised hundreds of millions of dollars, okay? And again, the biggest piece here, it's not that I'm advocating for major record labels. I'm talking about everyone else. I'm talking about what has already happened, what is now continuing to happen, and there's these lawsuits by major record labels. Okay, they're gonna get paid. Especially now, I have never been so confident having read this copyright report and having the Copyright Office itself come back and say, this is kind of BS. And so that's gotten me thinking, I go, what about my music? And more importantly, what about your music? If you're an independent artist, and we are the ones that make up the far majority of the music business, of the music that was likely trained on by these companies, and you're not going to get paid. So we're looking at this analysis real closely. All right, let's keep going. Public benefits. Is it of public benefit to just let these companies do their thing? And you know what? The Copyright Office, funny enough, did kind of an international screenshot in this analysis, okay? And I'll talk about this for a sec, because in the public benefit, we had looked at like UK copyright law and how the UK government right now is considering changing and becoming more of an opt-out system, because they're like, we really want to encourage technical development, AI development, and so we don't want to have these inhibitors for these companies to go and train on what they need to train on, because as we've all learned together today, you have to go and train on a lot of stuff. And the reality of having to go and like clear all those things, it's just such a headache. And so even the UK government has been considering, maybe we should just go ahead and make a change. So going back to the public benefit, is it of a public benefit that these companies would be able to do these things, because it really is in the advancement of science and art? And of course, there are commenters who say, well, no, of course. And especially if you are pro tech, we can see we want to remove these impediments. And that's why it's important with kind of what's happening right now and the firing of the director of the Copyright Office of just, is this a big effort to remove these impediments? But every time there's a removal of an impediment, it's to the detriment of creatives. And that's why we're talking about this. OpenAI, for example, stated that generative AI promises to augment human capabilities, thereby fostering human creativity. Meta has asserted in litigation that its open source models enable platforms built on Llama to bring innovative and, in some cases, potentially life-saving services and technologies to market. On the other hand, others asserted that unlicensed use of copyrighted works to train AI injure the public by impeding the growth of the creative economy and authors' ability to earn livelihoods. The copying involved in AI training threatens significant potential harm to the market for or value of copyrighted works, where a model can produce substantially similar outputs that directly substitute for works in the training data. It can lead to lost sales, even where a model's outputs are not substantially similar to any specific copyrighted work. They can dilute the market for works similar to those found in its training data, including by generating material stylistically similar to those works. So weighing all the factors together, we observe the first and fourth factors can be expected to assume considerable weights in the analysis. And again, what are those factors? It's the purpose and the character, right? So they were like, is it for commercial purposes? Was there transformation and all that? And then finally, what is the impact on the market as a whole? So they're saying those are the ones that the court are going to weigh on the most. In applying current law, we conclude that several stages in the development of generative AI involve using copyrighted works in ways that implicate the owner's exclusive rights, aka it is copyright infringement. But the point of fair use is that even when there is copyright infringement, if something is fair use, it's a defense and you won't get into trouble. There won't be liability. So what they're saying is that basically what we're talking about here is that in order to have the AI do its thing, it is infringement. Okay, we've established that. The key question, as most commenters agreed, is whether those acts of prima facie infringement can be excused by fair use. Various uses of copyrighted works in AI training are likely to be transformative, right? So this piece, if it is used in AI training, it is likely transformative. The extent to which they are fair, however, will depend on what works were used, from what source, for what purpose, what are the controls on the output, all of which can affect the market. When a model is deployed for purposes of such an analysis or research, the types of uses that are critical to international competitiveness, the outputs are unlikely to substitute for expressive works used in training. Let me just explain that again, where the new thing that is being created, right? If it's especially an expressive output, it's not the same as what it originally trained on. It is something new. It is something different. That's where we're going to be like, okay, it's closer to fair use, essentially. But making commercial use of the vast troves of copyrighted works to produce expressive content that competes with them in existing markets, especially where this is accomplished through illegal access, goes beyond established fair use boundaries. For those uses that may not qualify as fair, practical solutions are critical to support ongoing innovation. Licensing agreements for AI training, both individual and collective, are fast emerging in certain sectors, although their availability so far is inconsistent, right? So going back to, is it a pain in the butt for these companies to go and get licenses? Yeah, and that's what they're saying. But the Copyright Office goes on to say government intervention would be premature at this time. So the Copyright Office comes back in a fairly pro-creator way, and just to say, at the end of the day, we have a system in place, and AI companies seem to be trying to usurp that system and to say, well, because in certain instances, and we saw cases like the Google case, where you have tech companies that are taking massive amounts of pre-existing copyrighted stuff to train on, but they're creating something new that has like value, right? The public interest, it's a valuable kind of thing. And it's, most importantly, it's transformative. It is something new. It is a brand new database. They were synergizing and synthesizing data for some new purpose. They go, in these cases, it seemingly looks like fair use to us. And so as we apply these now to the case that affects particularly musicians and producers, music creators, and rights holders, to the extent, and if you knew that these companies, in fact, have already trained on your music, that's the thing I want to plant with you. They've already trained on your stuff. And we sit back in the back seat and we're watching as these record labels that have a lot more resources take up action. They say, absolutely not. It's not fair use. We never consented to it. And we're going to sue you. And I'm sitting here reading this, and you have the Copyright Office itself saying, we don't think that this is fair use. And I know for a fact that this report, as it stands right now, we'll see if it gets greatly revised at some point, but as essentially the chief legal and policy advisor to Congress, to federal agencies, and to courts, this is an extremely persuasive document. It's so persuasive to me that I'm thinking about what we need to do on behalf of all the independent artists who are not being taken care of in this situation. They're not being defended. You're not going to see dime one. And so yet again, even in the best case scenario, the record label wins the day. Major record labels, once again, have a paycheck and you have nothing. Please make sure to get up on the email list, okay? I'm going to keep you posted. I'm not sure what I'm going to do with this, but I'm starting the process. I'm top music attorney, Miss Crystal.